So hi folks, Alex Woods here, civil litigator with Redwood Legal. So a big announcement, I'm going to be publishing a book called Representing Yourself in the UK County Courts. Very exciting, sexy title, I know. But it is a practical guide and something of a paperback wingman for anybody who's deciding to sort of fly solo in the county courts of England and Wales. This is a growing issue. There's been some judgments come down recently that I'm going to talk to you about in just a few moments. And if you are a litigant in person, you clearly need some level of guidance, whether it's free online resources or whether it's actually a book, or indeed whether or not you might need to use a lawyer on a sort of selective kind of lawyer-like basis. So this video really is just to give you a few useful pointers and flag out some key areas that I think litigants in person should be aware of if you're taking the brave and bold decision to run a piece of litigation yourself. Now, the very first thing to say is, I think having examined this and finished the first draft of a book on it, the civil litigation system of England and Wales is complex and it has evolved. Yeah, I like to compare. Let's imagine you're just you're actually having to decide whether or not you want to bring a claim or defend a claim in the county courts. It's a little bit like flying an aeroplane. It's not as simple as riding a bike or driving a car, things you could probably do, without any assistance or any training whatsoever. It's a bit more like getting into an airline and getting into that cockpit, because you've got the civil procedure rules. Now, have a look, Google civil procedure rules, and you'll see that there are like over 90 sections with as many practice directions as well. And litigants in person, God bless the government and the powers that be and the judges who decided this, it all goes back to Lord Wolfe and his Access to Justice Act, have decided that litigants in person do have to comply with these rules and they won't be given any special concessions. So I like to think of, entering into the wonderful world of civil litigation as a little bit like flying an aeroplane, quite frankly. This means you do have to get familiar, just as you might do if you were flying an aeroplane, with the rule book of the civil aviation authorities and so on and so forth. You need to get a little bit familiar, at least, with the civil procedure rules. As I say, these are freely available online, and you can Google a lot of things, small claims track or discontinuance. Just put in those words and CPR after them. That will take you to the relevant section and the relevant parts that are relevant to the issue that you're facing. The next key thing really is track allocation. I flag this up because a lot of people out there are labouring under the misunderstanding that there's some sort of special small claims court in this country. Perhaps they're confusing it with an American model. It's not. When you issue a claim, it is just a claim. Even though it might be under 10,000 or over 25,000, under 10 small claims track, over 10,000 up to 25,000 fast track, over 25,000 that's a multi-track case. Typically half day for a small claim, 1 day fast track, 2 day trial plus for multi-track. When your claim is issued, the court system doesn't look at it as a small claim just because it's under 10,000. You can't elect your case to be a small claim. The court will decide at a reasonably advanced stage of proceedings what track to allocate your case to. Now this can have serious implications, and I'll just illustrate with one single example. Let's say you issue a claim under 10,000 and you are faced with a counterclaim, a stout defence and a counterclaim that takes the total value of the claim that's in dispute way above £10,000. You could then find the case allocated to the fast track. Also, if you want to discontinue a claim after you've issued it, but before it's been allocated at what's called the directions questionnaire stage, you're liable to pay the legal costs of your opponent upon discontinuance. So you don't want to discontinue until it's been allocated to the small claims track. Okay, so people are also unaware of the fact that actually, even if your case is on the small claims track, a judge could decide to award you legal costs, or your opponents their legal costs, because a party has behaved unreasonably. So in summary, what I'm saying is, don't automatically assume that your case, simply because it falls in one of those value bands, is going to be allocated to the small claims track or the fast track, multi-track. Look, the vast majority of small claims that probably, that are well under 10,000 should be allocated to the small claims track. But that is not set in stone. That's simply the normal type of allocation. The court will have consideration of a range of other factors when it comes to deciding on which track to allocate your claim. So it's not a small claims court, it's a small claims track, and it's the same court and the same judges, although the procedures are relaxed, there's no disclosure. The fundamental difference with the small claims track is that win or lose, legal costs aren't awarded. The court will not make any award about legal costs whatsoever, okay, unless a party has behaved unreasonably. This means lawyers generally are kept out. The third thing I wanted to talk about in respect of litigants in person is the importance of costs. You need to understand that unlike, let's say, family proceedings, criminal proceedings, employment tribunals, cost is a big issue in civil litigation. Now, you may be representing yourself, but you may be coming up against an opponent, let's say it's a public body or a corporation or a bank, let's say, who will not hesitate to instruct lawyers, even though it may be a low-value claim. So you have to be alive to the issues of costs in civil proceedings. And if you make errors during the course of what can often be lengthy proceedings, at each individual hearing, at each individual stage of those proceedings, a judge, a court, can make a specific order that one or the other party picks up the tab, pays for the costs of that particular hearing or stage of the proceedings. That just illustrates to you that costs is a very live issue. So before you get involved in civil proceedings, you've got to make a commercially savvy decision, by assessing whether the other party is likely to be represented, by thinking whether or not thinking twice about representing yourself. Perhaps you should instruct lawyers. Perhaps you can get a lawyer on a no-win, no-fee arrangement. Perhaps you can use just a little bit of advice, and this is at the very beginning of the case. So you can see how costs are a very real and a very live issue, and something you have to take account of. Treat civil proceedings as a commercial enterprise, and that means budgeting, considering the costs, risks against the upside, to make sure that it really is worth bringing the proceedings in the first place, because life is too short to get bogged down in an expensive, emotionally draining piece of civil litigation. Believe me, it's emotionally draining enough for us lawyers. Okay, that brings me on to the final point, which is, you're going up into the air. You probably need a little bit of a trainer or a little bit of a navigator, or you need a little bit of guidance. You can find a lot of decent guidance online, actually. If you just Google the Ministry of Justice, and you'll find that there is guidance on how to bring, for example, small claims, how to bring claims. If you Google litigants in person, you'll find that actually in 2013 there was a big guide produced by the courts themselves to help litigants in person. There's a Citizens Advice Bureau, of course. There are free services. I've noticed, for example, Martin Lewis, the famous consumer champion, has a section on how to bring your own small claim. Really, Google it. There is a lot of good information out there, as well as articles from lawyers who operate in this area. Now, just to conclude, I mentioned at the beginning of this vlog some recent case law, Because one of the questions you might be asking yourself is, well, how does a court treat a litigant in person? Are we going to have special concessions because we can't get a head around this? You know, these ridiculously voluminous civil procedure rules and the practice directions. It's a lot to expect to anybody to make sense of them, certainly in every area of the litigation. Unfortunately, there's been recent case law on this, and I will link the case law in the description box below, which says that no, litigants in person must be as compliant as anybody else, except in special exceptional circumstances where it's clearly, the civil procedure rules are clearly impenetrable or obscure. And this happened in this particular case where the litigant in person missed a deadline for serving papers on their opponent. They had to serve by post. That was what was directed or ordered, and they served by email. Now, you wouldn't think that would be a major problem, would you? But unfortunately, the order had said by post, and it went all the way up to the Supreme Court, the highest court in the land, and they ruled against the litigant in person. So I'm afraid the conclusion is you do have to comply with those civil procedure rules. Now, by the same token, in practice, my experience is the courts and the judges will be sympathetic and give a lot of airtime and a lot of leeway when it comes to, you know, being at hearings, perhaps not having every bit of paperwork you need, or not, you know, having made a small slip somewhere, missed a date for service of documents. If, you know, you will find in practice the courts and the judges will be sympathetic, but ultimately, you know, if push comes to shove, they are going to require litigants in person to be compliant with those civil procedure rules. God bless them. No point in getting annoyed about them. That's, you know, you just got to grit your teeth and get on with it. I also want to give you two little bit of rays of hope. Well, I hope it's more than rays of hope, but some positives out of this particular YouTube vlog. The first is, don't forget, as a litigant in person, those lovely civil procedure rules allow you to claim your own costs. It stipulates £19 an hour, so that's the work that you're doing on your case in place of a lawyer. Okay, don't forget costs. Always be keeping a note of the amount of costs that you've been expending on your case so that they can be claimed at the appropriate time, usually at the end of the case after the judge has made a finding for you. Okay, now here's the even better bit. There's one case, and again I will link it in the description box below, that is also reasonably recent, in which a professional ran his own case. He ran it beautifully, and he was able to convince the court that his hourly rate, and that he'd lost the opportunity of doing his normal financial job as a professional, should be £150, and the court sided with him. So if you are a professional and you're having to sacrifice time on your business, the court, and you can prove that you've lost that time in that business, the court will award you, you know, what you asked for, which in that case was up from £19 to £150 an hour, which represented a very substantial costs bill indeed. And also, just to round up and just to end on a really positive note, I had an email from a client just a few weeks ago, and he'd been watching these videos, and I just wanted to quote you from the email. Dear Mr. Redwood, you probably don't remember, but around last July I made some inquiries about representation together with a thank you for your very good guidance. Your vlogs were a key support for me in my small claim against a client who refused to pay. The defendant's wife is a lawyer, and the defendant himself is a professional involved in large government-level finances, so I was up against formidable opposition. The defendant used his knowledge and position to try and intimidate me from the beginning. My claim finally went to a court hearing, and because I was guided by you, I was well prepared. Sounds like I've written this myself, doesn't it? My documents were in apple pie order, something I hammer home in these videos, and even though I missed a couple of points, In general, my performance as a litigant in person was good. And it goes on. Anyway, he also attached the judgment, and I'm going to put this judgment up redacted. The client's perfectly happy for me to use it in this way. So you can actually, at least in a small claim, I would think twice about it in a fast track, especially in a multi-track claim, get away with running your own claim. You should be able to run your own claim entirely for free just by means of legal resources that are available online. Final plug, we're building a Litigants in Person website. I'll be publishing my book in the next month or two, so stay tuned.